Well, good evening, everyone. I start by acknowledging the traditional owners of the land on which we meet this evening, the Wurundjeri people of the Kulin Nation. Thank them for their care of the land and pay my respects to their elders past and present. My name is Chris Mackey and I'm Professor of Public Scholarship and Professor of Greek Studies at Trobe. And on behalf of the University, I welcome you to the sixth event of the Bold Thinking series for 2016 called Free Speech, How Far is Too Far? I'm pleased to say that tonight our panel of experts will discuss revenge porn, decency and the law in what promises to be a robust conversation. I'm pleased to say that La Trobe is one of Australia's leading universities for law and legal studies, and tonight's discussion in particular will consider free speech and technology in the age of social media and what this means for lawmakers in terms of regulation and legal liability. On tonight's panel, we have, down the end there, Nicola Henry, who is Senior Lecturer in Crime, Justice and Legal Studies at La Trobe University. Her research focuses on the prevalence and nature of sexual violence and the legal and non-legal responses to these harms in Australian and international contexts. She's recently completed an ARC discovery project examining digital abuse and harassment with Dr. Anastasia Powell from RMIT, and she's currently the lead chief investigator of a criminology research grant that focuses on the non-consensual distribution of nude or sexually explicit images, also known as revenge pornography, which we're going to focus on tonight. We also have Patrick Keyzer, gentleman here, who is Professor of Law and Head of the Law School at La Trobe. He's a barrister who's represented people in Victorian Supreme Court, High Court of Australia and United Nations Human Rights Commission. In his book, Open Constitutional Courts, Professor Keyzer argued that constitutional cases should be seen as acts of political speech and that consequently litigation cost orders should not apply in constitutional cases. More recently, he's been researching the impact of social media on the courts and remains puzzled by the paradox that some people will publish things to the world on social media that they would never say to someone's face. How true that is. He's a stout defender of the power of democratically elected governments to determine the limits of free speech and has a long interest in the topic, having taught constitutional law for 25 years and appeared in counsel as counsel in more than a few cases that have raised thorny speech issues. Joining Nicola and Patrick is Chris Berg, gentleman down after Francis, and Shen Narayanasamy. Sorry, I practiced too. Chris Berg is Senior Fellow with the Institute of Public Affairs and heads up the Red Tape and Criminal Justice projects. He's the author of 5 books, including In Defence of Freedom of Speech, From Ancient Greece to Andrew Bolt. Chris joined the IPA in 2004 and is one of Australia's most prominent voices for free markets and individual liberty, and a leading authority on overregulation, economic freedom and civil liberties. Shen is GetUp's Human Rights Campaign Director. She leads the No Business in Abuse campaign, which targets corporate involvement in mandatory detention of asylum seekers, and #LetThemStay, which aims to prevent the deportation of hundreds of asylum seekers to Nauru. Shen's background is a human rights lawyer and advocate working in Australia and across the Asia-Pacific region on issues of economic justice and land rights. So that's our panel. I will now hand over to tonight's host extraordinaire, radio personality, Francis Leach. Please join me in welcoming the panel.
Thank you, Chris. Thank you, Chris, and welcome to the 6th edition of the Bold Thinking series on this issue, which as a broadcaster and a journalist is dear to my heart. We live in a different age to the one that I started broadcasting and being a journalist in, though. Back in those days, if you wrote a story, it would be published in a newspaper at best. If you were making a radio piece, it would be on reel-to-reel tape that you would cut with a razor blade and mark with a pencil. These days, you take a photo on your phone, you publish it to the world, and the consequences, for some, can be devastating. I'll give you a very personal example of how powerful this is. So a couple of weeks ago, a friend of mine posted a picture of me holding my baby daughter in my arm. This is about 13 years ago. I had her with a bottle of milk, and myself, I was taking a drink from a bottle of beer, so both of us are drinking. And that was published on Facebook. 2 weeks later, my photo with my baby daughter turned up as a laugh line on the Ellen DeGeneres show. So they pulled it down from my friend's, I don't know how it happened, they pulled it off Facebook of my friend's Facebook page and just used this photo from 2003 or 4 on the TV show in the United States, on one of the biggest television shows in America. I mean, it just blew my mind, but it gave me an insight into the power and responsibility of all that use these technologies and what they publish and what you send out to the world, because that's a fairly benign experience of technology, freedom of speech, and the use of social media. But for some people, in other circumstances, the consequences can be much more grave and much more difficult to navigate. And that's where we start tonight when we talk about revenge pornography and sexually abusive imagery, because photographs that might have been taken in circumstances that people would never imagine would go beyond the boundaries of their particular situation can have extraordinary consequences. And Nicola, Henry, we'll start with you on this because this is your area of expertise. We have to start by defining the term revenge pornography to understand what we're actually talking about. So this is something that you've done a lot of work on.
Okay, thanks, Francis. So revenge pornography is a media-generated term. I find it quite a problematic term because it implies that the motivations for the distribution or the creation of intimate images is exclusively about revenge. But it also implies that the images that are distributed or created without consent are pornographic. And they may not be pornographic, they might be intimate images of some sort. So the term that I prefer to use is image-based sexual abuse, but given that revenge porn is a slightly more catchier term, I'm happy to keep referring to that tonight.
Chris, if somebody consents to being photographed, and not all of what Nicola's talking about is with consent, but if somebody consents to being photographed by somebody else, are they then, in some sense, handing over the right to that person to do whatever they like with that image?
I don't think they're handing over the right to do with the image whatever they want, but they're certainly handing the capacity to do whatever they want. That certainly doesn't justify anything that someone does, but they are taking a very they are taking a risk that that person is going to betray their confidence in some way, betray the implicit trust, the implicit contract that they had when they took that original image. The question here, though, is, well, what should the law do? So what can the law and what should the law do in these sort of circumstances that isn't going to cause serious consequences to other things that we value as well, which is things like freedom of speech, the capacity for us to discuss matters of public interest and so on and so forth. And I think that is a much more challenging question, or that is a very, very challenging question. So while...
As a libertarian, in that situation, how would you feel the law should or shouldn't deal with it?
Well, I think the law, so for instance, we have a number of laws on the book that cover things like menacing, harassment, stalking, intimidation, and that sort of thing. Now, I would look in those directions. I would look to either use the laws that we have better, or in some cases strengthen them if it's demonstrated that those laws aren't working as they should. But those would be general laws. Those are laws that apply to all stalking, harassment, intimidation, menacing behaviour. I think we've got quite a lot in the legal system to learn about how the laws are functioning at the moment. I think the police have a lot to learn about how best to use these sorts of laws. But that's the direction I would be looking. And that doesn't violate any libertarian principles by any means. It should not be lawful to menace, stalk, harass, intimidate someone. I can't see an argument other way.
Can I turn this way and ask you, Patrick, should the law be trying to, in this sense, restrict people's ability to publish those sorts of images?
Definitely. I mean, I'm in furious agreement with Chris's analysis around the need to use our legislation around stalking and menacing behaviour and harassment and what have you to manage situations like this. I just wonder if our current system of legislation, I wonder if we should be going a bit further than just using our current legal system and our current legislation and rules better I think we may have to engage in quite a bit more regulation of social media and the use of digital media, because it seems to me that the fact that the Criminology Research Council and the Australian Research Council have determined that there's a need for research of the sort that my colleague Nicola Henry engages in is, and it's clear to anybody who uses social media and the internet, that there's a lot of awful activity and a lot of terrible things going on in social media and digital media that need to be regulated so that we can have a more civil discourse and to protect people.
But Shen, trying to regulate the internet and thought on the internet and exchange of ideas in that space is like trying to wrap your arms around a cloud, isn't it? It's just going to disappear the moment you try.
Well, I think you've got to think about what the purpose of the law is and how that marries together with a modern society where we are in many senses existing in a real world, which the law tries to cover quite well, but we're also in a modern society that now is increasingly interacting on a virtual world. So I think to make the argument that you should be able to engage in behaviour in a virtual world that you wouldn't be able to in real life, and the law should somehow make a distinction between the two, doesn't make sense to me. So I think if what you're doing in the virtual world is causing harm, is menacing, stalking, harassment, but for some reason the parameters of the current laws don't adequately cover that virtual world in a sufficient and kind of rigorous manner, then we should extend the law.
Well, I want to turn back to you, Nicola, on this, because you, once again, have done the research. And what are some of the known consequences of that sort of behaviour when images of that nature are published? And I gave you my rather silly example of how quickly it can proliferate. So give us an insight into what your research has told you.
Okay, so I think the first thing is that there can be different impacts on different victims, and that's really important to acknowledge. But there are certainly cases of people who have gone on to commit suicide after their images have been distributed online. There are cases of people who are victims of sexual assault where the rapes, sexual assaults have been recorded, photographed or filmed, and those images are then distributed afterwards via mobile phone or on social media. So the impacts for sexual assault victims are very serious and significant. They've already experienced, something horrendous, and then those images are then distributed as a kind of further reminder about what they've gone through. But I think the other thing too, just to remember, is that what we're also talking about are victims of domestic violence. So we, in the research that we've done, we spoke to victim support advocates who told us about the experiences of some of their clients, and that images were being used as a way to prevent the victim from pursuing an intervention order. Images were used as a way to coerce the victim into further unwanted sexual acts, and images were also used, threats to distribute images, as a way to force the victim to stay in the relationship. So what we're talking about, obviously those sexual assault, domestic violence examples are quite extreme, but these, it does depend on a whole range of circumstances as far as the victim's concerned, their cultural, ethnic, racial background, their age, their sexuality, whether they've got a disability. So we really have to kind of think about serious impacts, but different impacts for different victims.
Chris mentioned earlier on that there are laws to deal with the issues of stalking and harassment, but are they effective in dealing with the new technologies in which these events might occur?
Well, I don't think so in relation to the non-consensual creation or distribution of intimate images. So we do have the telecommunications legislation, which makes it an offence to use a carriage service to menace, harass or cause offence. And that law is not being used in relation to so-called revenge pornography behaviours. It was used in relation to the Skype scandal, where two defence cadets recorded a consensual sexual encounter and then streamed it via Skype live in the next room to a bunch of other guys. So it was used in that example, but not in relation to the other forms of image-based sexual abuse that I've been talking about. So that's one problem. The other thing too, it doesn't really capture the harms associated with the behaviours that we're talking about. It also doesn't capture situations where a carriage service isn't being used. So there are cases where, there was one very famous case in Victoria where a guy recorded on a video camera him and his wife having sex, and then went around and showed her friends and family members the video. So this is not a carriage service as such. So I guess, that telecommunications legislation is limited in that respect, and I think having a specific criminal offence in place does clearly communicate, that this is something that should be recognised by the Australian community as resulting in serious harms, and that's why I believe we do need more regulation in place.
More regulation, Chris, how does that sound?
It depends what it's for.
Yep.
I'm open to, and this is an area that I'm not a lawyer and I haven't studied it to the extent that you have, obviously. I'm open to the idea that we need to strengthen harassment, stalking, and so on. And certainly, I'm particularly sympathetic to the argument that technology-based law is a bad way to go. So the idea that we have menacing on a carriage service, well, things fall within the cracks. It's not neutral to the harm that it causes, and so forth. I'm very, very uncomfortable, however, in, so that's the primary harm. I'm very uncomfortable with the idea of regulating social media services or so forth, because that's not about the harm that someone specific did. It's about the idea that to share an image is to risk its censorship. I think fundamentally, Shen, I have to disagree with you. You are, if you do something on the internet, you are just as liable as if you'd done it in a room like this. If you say something defamatory on the internet, you are liable as you would if you said something defamatory here. Sometimes the issue is that it's really hard to find out who said it. So there's an anonymity issue. Sometimes the issue is, and I alluded to this before, the police or people in authority you go to don't realise that law applies. So there's lots of stories. I've looked quite in detail at cyberbullying as an issue. There's quite a few stories about people who are bullied on the internet on, say, Facebook, will go to a local police station and the police will say, well, we can't do anything about it. It's on Facebook, and Facebook is an American company. Now, one, that's not true, but they can do something about American companies. But two, it doesn't matter. It doesn't matter whether it's using an American service. It's someone in Australia bullying you. That person needs a visit from the police. I think there's a great deal of education and there's a great deal of learning about the limits of the legislation we have in place at the moment. And as you point out, the legislation we have on the books isn't actually being used as much as it could be. Now, that might be an education problem.
So Chris is saying, and I'll throw it over to Shen and to Patrick, that the laws are there probably underutilised and that there's probably a cultural misunderstanding about both the impact of that sort of communication on the net and how to deal with it. Is that the solution? I mean this in two ways, with the police and enforcement authorities, but also within our community. Do we need to take responsibility for an ownership of what's said online and change the culture of that so that people are aware of the consequences of their actions?
And are you talking broadly about what's said online, or more specifically the sharing of images of sexual abuse?
Let's start. Well, we can narrow it down to that.
Yeah, I mean, I think that the point of what I was trying to say is that if the law is struggling with dealing with new spaces, then the law should be extended. But the best people to ascertain whether or not the law is struggling is actually the legal experts. Right? You need research to know whether or not the specific laws apply, and they're just not being utilised. So I think that's kind of an area that I'm kind of happy to leave to the legal experts and the research heads. But I think as a member of the public and a member of an organisation that uses social media enough, we can see the logic that, given that it's a new space and it's an increasingly important space, that if your behaviour in that space causes harm in the same way it would in the real world, then that should be somehow catered for by the law. Like, there should be some level of equality. In terms of like the notion of free speech on the internet and ways in which you can manage that, from the perspective in which we sit, there's also been an incredible positive about the flowering of discussion and debate and free speech that happens on the internet and happens in social media. So I think, it's an incredible boon in some ways, but I also think that there's clearly openings and ways in which the law is struggling, and we're struggling to keep pace with what's happening. And in that sense, we do need to, invest in research and invest in understanding whether or not current laws are sufficient or new laws need to be brought in, because there is an incredible scope for harm.
Because Patrick, reading your material, you're very strong on the notion that there needs to be a regulation of some sort in the social media space, and that people need to be held to account either by the state in some way.
No, absolutely. I mean, and I guess just repeating what I said in print a few weeks ago, I find it remarkable that we have such an effective system for parking regulation. So if you park in the street and somebody gives you a ticket, and yet you can be a horrible troll on the internet and engage in racial discrimination and sexist behaviour and terrible things that are against our laws, but there's no enforcement of it. So in a sense, I agree with what Chris said a moment ago, that maybe we need that further attention, and there needs to be a knock on the door from the police, as he put it. And
The thought police, then? Is that what you
well, I don't see it as the thought police. I mean, necessarily. I mean, if you use Section 18C of the Racial Discrimination Act and Section 18D and the controversy around that as an example, and we're steering away from image-based sexual abuse here to sort of current debates around freedom of speech. You actually, when you read those provisions, you see that Section 18C does proscribe offensive and insulting and humiliating racial discrimination, but Section 18D allows that activity to take place if it's reasonable and in good faith. So there is a balance there that the law already constructs. And I guess my view would be that I don't see any reason why we can't have a parking ticket style infringement system for social media to shut down the trolls. Because I don't want my children seeing what the trolls have got to say, and I think people should be punished if they engage in rampant trollism.
Well, I did my homework, so I brought both sections 18C and 18D here. So in case you haven't read them, I'll read them, at least part of them for you. So Section 18C of the Racial Discrimination Act makes it unlawful for someone to do an act that is reasonably likely to, quote, offend, insult, humiliate or intimidate someone because of their race or ethnicity. And then there's the kicker on Section 18D of the Racial Discrimination Act, which contains exemptions which protect free speech. These ensure that artistic works, scientific debate and fair comment on matters of public interest are exempt from Section 18C if they are providing they are said to be done reasonably and in good faith. So there's a number of tests there, Chris. Does Section 18D balance out Section 18C satisfactorily for you? And what do you think of Patrick's idea of parking fines for trolls?
Look, it's creative. I like that. To your question, we thought, or we as the Australian community, had a general belief that Section 18D, if anybody thought about it at all, Section 18D did balance out Section 18C because
you thought, but you don't anymore.
We don't anymore. And the reason that there is a controversy is because of the Andrew Bolt case and because of the more recent QUT students case. In the Andrew Bolt case, Andrew Bolt was found not to have met the criteria in 18D for two reasons, two conjoined reasons. A, he made factual errors, and B, he was excessively sarcastic and seemed to be engaged in ridicule at the time. Those two were read together by the judge, and the judge said, because of those two facts, I cannot say that that was done in good faith. Now, that is not actually a power I'm comfortable giving to a judge in any circumstance, particularly on a matter of public controversy. The idea that excessive sarcasm might be a pivotal factor in whether speech on a political matter is lawful or unlawful, I'm deeply uncomfortable with. So the second thing that's happened, of course, is the QUT students case. In this case, which hasn't actually been finally resolved, it's in front of the Federal Circuit Court, I believe. A couple of students made some comments on a Facebook post about being kicked out of an Indigenous computer lab. The main comment went something like, QUT is fighting segregation with segregation, something like that. I might be misquoting slightly.
No, you quoted it absolutely right.
Perfect. These students have been going through the legal system for the last 3 years. It might be decided that 18D actually protects them. It might be seen that that is in good faith, but as they say, the process is the punishment in this case. This to me seems to be prima facie evidence that Section 18C and 18D working together have a much too lower threshold for action.
Doesn't Chris make a point there that this is, it would seem on what Chris has said, and I've read a little about this case as well, that there's prima facie evidence of administrative harassment for a student who asks what seems to be a fairly reasonable question: is segregation being dealt with by segregation? I think, personally, that that's a conversation worth having. Why should it be subject to the Racial Discrimination Act? I'll start with you, Shen.
Well, I think we haven't had a decision in this matter yet, and I think there's obviously some queries around the delays in that process. But the law isn't about the process, actually. So if you want to talk about 18C and 18D, talk about 18C and 18D. Don't use a specific case that we haven't actually had an outcome yet to determine whether the actual text of the law, justifies the process. I mean, trust me, the law's got a lot of process problems. This is not the only one. But I think that the real question, and the Andrew Bolt case is a really good example of this. Andrew Bolt isn't just a nobody, he's a journalist, first of all, and he was found to have made significant factual errors, and done so in a way that was not reasonable and not in good faith.
Can I read a bit of the judgment that pertains directly to that? So Judge Bromberg, who was the federal court judge who made this decision, said, quote, "The facts on which those opinions are based must be summarised in the same publication or be already widely known, and they must be truly stated. In other words, they must be true facts and not false ones." So he's saying basically in the judgment that whilst under 18C it might well be protected under by 18D, the fact that it wasn't based in fact means that it doesn't stand. Isn't that fair enough? I'll ask Chris just quickly. Yeah. Isn't that fair enough that facts matter when it comes to freedom of speech?
No, of course facts matter, and no one is defending untruths, and no one is defending lies. But that's not. That doesn't speak to should it be unlawful to offend, insult, humiliate, or intimidate someone. If you've made factual errors, that doesn't speak to, in my view, it doesn't speak to good faithness. And certainly in combination.
It could well do though. If you've deliberately or lazily constructed an argument based on what your already held position is without doing the research. Certainly, it doesn't speak to good faithness because it had to be combined with, as the judge suggested, it had to be combined with the sarcasm. If he'd just made the factual errors, it very well might not have violated Section 18C. I think that's a big problem. But fundamentally, I don't think it should be unlawful to offend or insult someone. As I've said, humiliation, intimidation, that's a legitimate thing for the law to prevent. But the words offend and insult don't belong in Section 18C. That is the current debate about Section 18C, I have to say. There's a bill in front of Parliament saying exactly that. It's actually got incredibly widespread support amongst the human rights community, as well as the free speech obsessives like myself. Nicola, if we were to take a position like Chris's and say, okay, we're prepared to allow people to be offended and insulted, but protect them from being harassed and bullied, isn't that a fair balance to strike?
Sorry, can you repeat the question?
Yeah, if we're prepared to allow people to be offended and insulted, but protect them from being harassed and bullied and stalked, isn't that a fair balance to strike?
Well, I agree with what Shen said about, the process and about, with a complaint of racial vilification, the first step is that the person makes a complaint to a human rights commission, like the Australian Human Rights Commission, and then that gets investigated and that process gets followed. And most cases don't actually end up in court. But if you reflect on the cases that have been succeeded in court, there was a case called Tobin and Jones where this involved a man who was sending out leaflets with anti-Semitic content. And similar to the Bolt case, I believe, and Chris, you might correct me here, but that was found to be not in good faith. he made claims about, Holocaust denial and questioned, the numbers of Jewish people who were massacred and exterminated in the gas chambers. But then if you compare to another case that didn't actually go to court, but was Pauline Hanson and One Nation with her book, and I can't remember what it was called because I haven't read it, and never will. But that didn't, Section 18C didn't apply in that case because she did make comments about social welfare and Indigenous Australians, and it was found by the Australian Human Rights Commission that, the discussion of social welfare was a matter in the public interest. So to me, that a balance is struck, and those cases that have been decided demonstrate that balance is made. I don't think I've answered your question.
That's okay. But I want to throw to Patrick and Shen on this side too, about that, because that leads us to another current situation with 18C, and that's the Bill Leak cartoon, which is published in The Australian, which, and I know Bill, I've known him for a long time, he would continue to argue that was fair and free comment on an issue that most Australians either don't want to or won't talk about, because it's an issue around Indigenous family behaviour and Indigenous disadvantage. Why should he be subject to the racial discrimination legislation as he is currently being investigated by the Human Rights Commission?
Well, look, firstly, I understand that a complaint has been made about that cartoon, and it will go through the ordinary process. So there'll be an assessment of whether the cartoon was offensive or insulted Aboriginal people. And that's a perfectly reasonable inquiry for a Human Rights Commission or a court to have. And then Mr. Leak, who of course is supported by a media organisation with substantial resources and will have plenty of legal advice, no doubt, will be able to mount a case under 18D that his activity was artistic and that it was done reasonably and in good faith. And there is a case from about a decade ago called Brofo and the West Australian newspaper, which also involved a cartoon, and also by a cartoonist named Alston, who cartoons for the West Australian. And that cartoon depicted the head of an Aboriginal man who had been taken to England. His head had been chopped off and taken to England as some sort of horrible trophy some hundreds of years ago, and there was a controversy around the return of that head to West Australia, and a dispute about between various Aboriginal people who were involved in the repatriation of that head back to Western Australia, and some concerns about some grant funds and what have you. And it was a cartoon. There was a Section 18C case. The judge found that Section 18C was made out, but also found that the Section 18D defence was made out. So Bill Leak will have his day in court, like any of us, if we're alleged to breach the law. Just like Mr. Bolt had his day in court, and again he was supported by a media organisation with substantial resources, and he had substantial legal advice. I think focusing on Justice Bromberg's description of Bolt as sarcastic is perhaps a little bit narrow. The judgment the judge very carefully in hundreds of paragraphs went through the law very patiently and reviewed the requirements of reasonableness and the requirements of good faith, and reached a finding which, frankly, Mr. Bolt could have appealed if he wanted to. And I have no doubt that if he wanted to appeal that decision, that he would have been supported by the Australian in doing so, and I have no doubt that he would have appealed all the way. It shouldn't be overlooked that the leading High Court constitutional case on freedom to discuss political and governmental affairs was an appeal by Nationwide News, the Murdoch Press, in 1992. So if Murdoch Press want to go all the way to the High Court, they've done it plenty of times, and they could have done it in that case, but they chose not to.
But is it not a case that we set up a culture of self-censorship, that every time somebody wants to make a controversial comment, whether it's odious or not, thinks that the consequences are that they'll be dragged through a legal process that might be expensive and exhaustive. Is that the right way to handle this?
Well, I think you've got to look at two things. First of all, you've got to zoom out a little bit in the focus on 18C and consider this. So tonight when I came here, my partner was like, why are you doing this again? Because when you leave, you're going to get death threats on Twitter and you're going to get, you'll get the massive onslaught of hate that comes when a woman of colour speaks in public, which is why a lot of people don't, and why his argument is correct. You've got 2 kids, it's really scary for me, I don't want you to do it. So first of all that. Second of all, the fact that I named my son after my family background, not his, which is Italian, which means he's got an Indian accented name, means that he will have a dramatically different chance in the labour discrimination market than someone who had his father's name. So there's that. And then when you look particularly in the context of Bill Leak as well, at the statistics around Indigenous Australians in this country, the statistics in terms of interactions with police, life expectancy, self-determination, everything else, and you take the bigger look at the context, you go with the fact that the Racial Discrimination Act and racial vilification under 18C and D exist in a context where there is manifest racism and discrimination in our community which has significant harms on people, including harms related to whether or not people who look like me are able to speak in public. Just speak, not even about anything in particular, just speak. So in that context, when you look at it in that way, it really shifts who really here is the victim or who has the most to lose and whose speech is really being, infringed upon. So first of all, there's that. And then secondly, I think, the question I want to ask is, what is it you think you can't say? Like, can you not discuss policy in relation to Indigenous Australians? Can you not discuss the immigration program? Can you not discuss terrorism? You can discuss all of those things. What you can't say, what I want to know is, what is it that you think you can't say? What is being chilled? And if what's being chilled is the kind of language you've seen that's been targeted by the RDA, then good. Because frankly, if there's one area I'd like not to see it, it would be in newspapers and in public. The amount of crap I'm going to get into direct messages is nothing compared to this stuff.
Is that just the price of free speech, Chris?
No, and it certainly shouldn't be the price of free speech.
It is
absolutely.
Shen, though,
All those things are deplorable, absolutely deplorable, and I agree 100% with your assessment of the situation, and I can kind of obviously imagine to see it through those eyes. But there's also other values here that we have to protect, including the foundational right of freedom of speech. That is a very, very important thing. But I will answer your question, because it's often, in this debate, you're often asked, what is it that you cannot say? What do you want to say that you cannot say? And there's now, I don't want to say anything racist. I just want to be very clear about that. But I also don't want kids, to go through a 3-year process because they made a political statement that was deemed to be offensive by at least some people. I don't want us to be spending our time in political debates to be adjudicating them through the courts, which is what I see is happening with the Andrew Bolt case, with the Bill Leak cartoon, and certainly with the QUT case. This is not how we settle things in a democratic community. It's not how we settle things in a free society. I don't have the comfort that Patrick has with the day in court. I don't think a day in court is a positive experience. I haven't had my day in court yet. I suspect I'm not going to enjoy it when I do. I don't think that's something that we should positively aspire to as a community. That is the backstop. That is the emergency button. We shouldn't be trying to push as many things through the legal system. We should be trying to deal with them as a community, as a society. We should be trying to change social norms, not, sending everyone to their lawyers.
It's an important discussion to have, as you said, Shen, to zoom out and have the bigger question addressed of decency. And whether that's a value that needs to be protected and can be legislated to protect. I mean, you can't legislate away people's ignorance and what's in their heart, can you?
No,
Is that what we're trying to do by having restrictions on through, say, the likes of Section 18C?
Look, I think I think the law is important, both criminal and civil law, but there are major limitations with focusing exclusively on the law as a remedy to this problem. So I agree with Chris that we do need to think about other ways of addressing this issue. And I would say, at least in relation to the behaviours that I'm researching, which are around, revenge pornography, but also the rape threats online, also gender-based hate speech, that not all of the behaviours that I'm looking at should be necessarily subject to criminal or civil laws. But we do need to think more creatively about how to get justice for victims of these particular online offensive, obnoxious behaviours. So I think the law is important, but I think we need to do so much more. And this is an example of that, I guess, is having discussions, where we can talk about, the impacts and also the, balancing freedom of speech with freedom from discrimination and the right to equality.
And that particular issue will raise its head if and when there is a plebiscite on the issue of same-sex marriage, because the discussion in and around that is bound to skirt around the issue of hate speech and the sort of language that will hurt people. So the conversation needs to be had. It's going to be passed in legislation at some stage, or at least it's going to face a vote on the floor of the House at some stage. So how do we have that conversation without diving into the mire of the sort of language that might actually cause harm?
Well, I just don't trust people not to hate.
That's a fairly pessimistic view of the
No, I'm
world.
sorry. I'm sorry to be a pessimist. I fervently hope that the Senate doesn't support the plebiscite. I think that the notion of the plebiscite for marriage equality is reprehensible.
Why?
And I think it's reprehensible because these are people who just want the same rights as everybody else. You shouldn't be discriminated. They're being discriminated against on the grounds that they want to marry someone of the same sex, and that discrimination is inconsistent with international law. There are many, many countries around the world who've recognised this. They've recognised it for years and years in the United States. And here we are just drifting along with this plebiscite idea. The other fundamental problem with the plebiscite idea, I might add, is that the notion that we should take this particular decision and make it the subject of the $160 to $200 million plebiscite is absolutely ridiculous. And I'll warn you against plebiscites for another reason. I went to high school in California and I lived there between 1978 and 1984. And in 1978, a citizen-initiated referendum took place in California. And so they passed something called Proposition 13. And Proposition 13 said, if you want to cut your property taxes by a third, vote yes. Well, of course, everybody voted yes. And the next thing that happened was the schools, public transport, hospitals, all these California public institutions were absolutely gutted. They were absolutely gutted. And the quality of life and the civic institutions in that state just went downhill quickly. People think, oh, well, let's have a plebiscite about this particular issue, which I don't support for any reason. But even the notion of the plebiscite is deeply, deeply flawed and problematic. We have democratic institutions, let's let them operate. Let's have a vote in the House and let's have a vote in the Senate.
But can't we have a conversation in public, Shen? Can't we have a conversation around this important social change that allows both voices to be heard? And isn't that part of what makes a robust, vibrant, democratic community function?
Well, I think it goes, back to your question of trust. I don't know if it's that I agree with you necessarily on the hate aspect. I think it's that, and this is why we have those protections around racial discrimination and racial vilification, is that people can't engage in the debate without lying. And by lying, I mean going back to tropes that essentially say people are essentially different because of their race. And then drawing a whole heap of lies and misinformation out of that. And similar around the LGBTQI community. And I think it's not that they, already, you don't even have to be very futuristic about it. What we saw in the last federal election was just ridiculous, almost laughable, except they're so harmful. Tropes like that put out in, chat rooms and letterboxed and used in public discourse and in the context of an election. So I think, it's not even so much that people hate, it's that they can't engage in the debate without engaging in fundamental, reiterating fundamental things that this society knows to be demonstrably false, which is that there are any differences between people in relation to sex, in relation to race, and that there are any particular differences or particular, ridiculous stuff around sickness and health and AIDS, and just ridiculous. But part of the reason why we regulate it is because we know that those lies have worked. They've worked demonstrably well over time, which is interesting given the racial vilification stuff, and most of the court cases actually turn around anti-Semitism. We know this stuff works. It's why society tries to regulate it. And when you open up a plebiscite in that way, you just take all of the gloves off, and we know what's going to happen.
So is Shen right that in order for you and me as white middle-class men to enjoy our freedom of speech, other minorities have to pay a heavy price for us to enjoy that freedom?
No, certainly not. It's not a
As the
trade-off
predominant
deal.
culture?
It's not.
Sounds like it.
No, I disagree. Freedom of speech is an incredible, powerful thing for any minority group within a society. That's what it's specifically designed to protect, whether that is a political minority, whether that is a racial or ethnic minority. There's no point.
Not hearing too many Islamic voices or coloured faces in the Herald Sun writing about their experience, Chris?
Well, I don't only read the Herald Sun. I mean,
It's still the most powerful sort of media outlet in the
no,
country.
it's the most widely read media outlet. That doesn't necessarily mean it's the most powerful. We are in a position at no time in history where that has been less true, that a single media outlet dominates. The capacity for you to read alternative voices has never been higher. And though that capacity is protected by the freedom of speech, that also protects the Herald Sun. When it comes down to it, the majority doesn't need freedom of speech, the minority needs freedom of speech. Minority views, minority perspectives benefit the most from protection against the majority cracking down on it. The idea that freedom of speech is there for white men is exactly the opposite of the case, in my view.
Should we be looking, though, at trying to find a way to enforce a level of decency? This conversation on this stage is being held in an atmosphere of decorum, which is probably antithesis of what Shen's experienced through her experience online. So how do we find a way towards that? Is legislation the answer? Can we legislate away people's ignorance or their anger?
No, as I said before, I think that's one way to address this issue. But you've got to remember that law is very reactive. What we really need to be thinking about is installing a sense of digital ethics. And I think that needs to happen at the school level. It needs to happen at high schools, universities, but also the community more broadly, where we are having discussions around the ethics of distributing, for instance, images of another person without the consent, whether they're images of your baby or whether they're images of you in your underwear or doing something else. So I think, that's to me where we really need to put a lot of resources into this issue. And I do want to mention that in Victoria we do have legislation in place since 2014 that makes it a criminal offence to distribute or threaten to distribute intimate images of another person without their consent. But the problem is that not really many people know about this law, including police. And I think the problem is that there haven't been the public awareness campaigns that have accompanied that legislation. So that's, to me, really, really important to have some criminal laws in place, to have civil law avenues that are affordable, because most people, to be honest, can't afford to take legal action in the civil courts due to the insurmountable costs. But I do really think that we need a multi-pronged approach to dealing with decency and empathy and our relationships with other people, and that does need to start very young.
Shen, is it possible that Chris is right, that freedom of speech and an open competition of ideas has been powerful for minorities and has in fact allowed minority voices to be heard?
Freedom of speech generally as a concept?
Yeah.
Yeah, but then I suppose I think that I would overlay on that as well what Chris is talking about, if I can interpret you tell me if I'm wrong, is largely around a power relationship. So the most important and the where freedom of speech should be stoutly defended is essentially when a minority or a person is speaking some form of truth to power or something to a powerful entity. So, and this is what kind of annoys me about the 18C debate, because if I'm in Australia at this point in time and I'm saying that's the way I think of free speech, what is the central piece of legislation which contravenes that? Well, it's the Border Force Act, which, we just assisted Fitzroy Legal and Doctors for Refugees to take, and the Border Force Act, is the act restraining the freedom of speech of entrusted persons under the Act, which is anybody working, connected to the offshore detention centres to speak about what's happening there, which is fundamentally, it's completely in the public interest. It's a central issue in public discourse, and we're restraining people. And so we took a case, we assisted a case to the High Court in relation to the doctors and a specific category under that Act. And now the government have said, well, we're going to grant them a specific exemption. But of course, teachers, social workers, guards, anybody. If you're worried about free speech in this country, you must be worried about this. And in terms of everything that you would seek to put legislation before Parliament addressing, it would be that. But that has bipartisan consensus. And so what I want to see is the people on the barricades around the Border Force Act. But what I see instead is people on the barricades about this tiny little section where there is a good example of a bad process, which has nothing to do with the law. And really the question doesn't raise those issues of power. In fact, the issues of power run the other way, and the issues of minority voices run the other way.
So, Shen,
I'll go further. I agree with you. 100% agree with you. Section 18C is not the worst freedom of speech restriction on the book, in my view. We should be talking, and we do talk, I have to say. The Institute of Public Affairs talks about these other areas. I think that there should be more focus on defamation. I think we've reintroduced sedition laws in this country,
yes.
and we reintroduced them quite strongly. I think that these things need to be discussed. There's a huge range of laws that prevent the offence and insult. There's a law we found the other day that prevents offensive plant names. Now, I'm not saying that's a big deal, but certainly there's a huge range of laws that restrict our freedom of speech in minor ways and in significant ways. But that's not how politics works. As you know, as you say, there's bipartisan consensus on the Border Force Act. I don't think that that bipartisan consensus is going to change anytime soon. I do think that we could actually make some real serious and beneficial change on getting rid of the words offend and insult from Section 18C. I think that we should be talking more about issues like defamation. There's lots of different things that we can and do and should talk about. For instance, the IPA, in fact, I was very involved in this, supporting the unions in the Unions New South Wales case. Against the O'Farrell government, which was trying to prevent them from, in my view, speaking or expressing their opinions about political matters. We do get involved in these issues, but Section 18C is this big national debate, and it dominates conversations. Whenever you talk about freedom of speech, you apparently talk about Section 18C. That's not my ideal world, but that's where we are.
It's not the whole picture. Just to finish, before we throw it open to you for some questions as well. When I was a little bit younger, there was a fellow by the name of David Irving that wanted to come to this country, and he's a Holocaust denier, and he tried numerous times to get here to, peddle his idea that it didn't happen and that it was just a giant conspiracy. Was I wrong to argue that, bring him here, let him speak, because what he's saying is so patently absurd and stupid that no one's going to believe him, and that my trust in the good sense of thinking people, critical thinking people, would make his case laughable? Why shouldn't someone like David Irving be allowed to come here and make a goose of themselves?
Well, look, I have no difficulty with that in theory.
He was never allowed here to speak.
I have no difficulty with that in theory. I mean, I find, I think I'm with the Australian civil libertarian the fellow from Queensland. Sorry, I'm just having a brain fade. The fellow who described him as revelling in the unwholesome notoriety of his views. And I think that David Irving was very much one of those sort of unsavoury characters.
We don't have to like him.
We don't have to like him. I can understand that there would be differences of opinion about whether he should be granted a visa to enter the country to peddle his horrible variety of hate, personally. I think that those sorts of decisions, we should err on the side of avoiding hate. And that's why the Section 18C debate leaves me a little bit cold, but for different reasons than Chris. I just don't understand why we would want to have a debate about allowing people to offend and insult people on the grounds of their race or ethnicity. It just strikes me as bizarre that we would even think that that's worth our energy. And I share Shen's concern about the egregious restrictions on freedom of speech that are applied to people like the doctors in the detention camps who would draw our attention to the horrific human rights abuses that are taking place under the leadership of our government. I just want to say one last thing, though. I just wanted to make sure I got the chance to say this at some point, so I'm going to say it now, and that is this. I'm not aligned with any political party, but I just did want to make this observation that I think that a lot of people write off the Prime Minister, the current Prime Minister, for lacking leadership. But I think he's actually shown a lot of leadership by holding the line on Section 18C. He must be under a lot of pressure from people in the coalition to buckle and to change Section 18C. But he's held the line, and that's actually a mark of some leadership, in my personal opinion.
Well, Malcolm Turnbull is on the record as supporting getting rid of the words offend and insult.
Sure, yes, but he's not allowing it to happen, is he?
I will just very briefly make a point, although not tackle the entire issue about the Holocaust denial. It's often, so we spoke about the Tobin case just a moment, which was he's a famous Australian Holocaust denier. Holocaust denial is not actually, or my reading of the cases, is not actually unlawful in Australia. What he was found to have breached is being incredibly anti-Semitic while being a Holocaust denier. But the court,
the
court, as I understand it, separated very clearly a, quote, factual argument from a racial or anti-Semitic argument as well. Now, I'm with John Stuart Mill on this. I think that we should be able to air wrong views. I think the airing of wrong views makes true views stronger. I think being able to hear very, very bad views actually is a way that we ensure the solidity of our correct ones. Help us understand the Holocaust and understand the deep truth of the Holocaust. You're not going to understand it by preventing discussion of it, as wrong as those views are.
Is Chris right that critical thinking, the things that we would value, are actually fed by the idea of having to answer and rebut and to challenge wrong views, and we get stronger in our arguments about what matters?
Well, it's funny you say that because in my teaching, I always am very pleased when there's opposing viewpoints in the tutorial, because it makes for a more interesting discussion. So I guess that kind of context, but then just going to what Chris said about John Stuart Mill, yes, he did say that we need to air views, even if we need to get to the truth, and that's what one of the values that freedom of speech is geared towards. But he also did talk about the balancing act between causing harms and getting to the truth. And I think, the reflection on, there is no such thing as absolute freedom of speech. There are always restrictions. And I know we'll disagree about how those restrictions should be enforced, whether we should have criminal laws, whether we should have civil laws, whether we should allow someone to come into the country to speak about, support for raping women or anti-Semitic kind of views. But I do think, that there's always going to be a balancing act. And yes, I do think, we should be discussing things, but I think that harm principle that John Stuart Mill is so famous for is another really important dimension to this debate.
Well, it's been a balancing act up here tonight, and it's enough from me. Now it's over to you. So if you would like to ask a question of any of our panellists, stick your paw in the air, identify yourself, stand up and direct your question to the stage. I mean, we'd love your engagement here. So have we got somebody it's always toughest getting the first question out and then they come in a torrent. Does anyone want to start the conversation? There's a couple of hands going in the air. There's a gentleman just...
On 18C, sorry, I should stand up. On 18C, if the balancing act between 18C and 18D is so difficult for people like Bill Leake, the QUT students, and for Andrew Bolt to be able to navigate and know when to speak, how will someone of limited resources to fight a legal case confidently put across a position they think is controversial without thinking that they're going to have a significant amount of their savings wiped out?
Do you mind if I respond to that?
Absolutely.
I wouldn't want to give people the impression, although I am a barrister and a professor of law, that in what I've said tonight, that I necessarily endorse the use of courts for the resolution of all disputes. And in fact, I know that it's a very expensive thing to be involved in, and I often say to people who want to litigate, I say don't. The scenario that you advanced, though, if a person says something and they weren't aware that it was in conflict with Section 18C and they're brought to task for that, there's a lot of things that can be done very quickly, including a retraction, that mean it's not going to cost them any money at all. In fact, if Mr. Bolt had published the clarification or the statement retracting what he had said at the start of that matter, then it wouldn't have cost the Australian all of the legal fees and the court costs that they did defending the matter. And I've been involved in plenty of defamation cases, and they operate in much the same way. There's an exchange of letters, there's an apology and a retraction, and that's it. No one's spent any money on anything.
But part of that question also is that people looking at the Act going, if I write this or say this, am I going to be subject to the Act? And it acts as a form of self-censorship. And that surely, that's dangerous territory, isn't it? We're inhibiting people's right to, genuinely express themselves out of fear they're going to be subject to the law.
Yeah, well, they're already subject to the law. I mean, you've got defamation. So
why wasn't defamation used in these cases, do you think?
Well, because it's a specific legal context, right? But I think the question is, how difficult is it to genuinely, in good faith and in a reasonable manner, avoid offending and humiliating someone? It's actually extraordinarily easy. And I think this is why the Bolt judgment is so interesting, is because what it takes is not only just untruths or falsities, but falsities combined with like a recklessness or an intentional or somewhere in the middle kind of intention on the person who's doing it to reach that tenet that you require under 18C and D. Like it takes a fair bit of effort, and I think as you said, if you didn't intend that effort and you don't wish to defend it to the hilt, when it's brought to your attention, most reasonable people in our society say, oh, I'm so sorry, I didn't mean that. And if you did mean it, well, then you meant it.
Can I just make another observation about the Bolt case, just following on from what Shen had said? In that series of articles, Mr. Bolt was criticising light-skinned Aboriginal people for identifying as Aboriginal on the basis that they were generating some sort of advantage in doing so. Now, goodness knows why he felt the need to do that, but he did. He could have he could have retracted. And let's not forget that Section 18D does provide you with you can offend, insult, humiliate a person on racial grounds under the Racial Discrimination Act, as long as it's done reasonably and in good faith. So there is a balance between freedom of expression and the limiting of freedom of expression. And this is interesting. You can still access what he said. It's available on the internet, but it must be published with the retraction. So, and he wasn't ordered to pay damages. Now, the people who brought the Bolt case, the Aboriginal folk, they could have sued him for defamation. In fact, they probably still could, but they chose not to. And that's interesting because they didn't get any financial advantage out of running the case through Section 18C of the Racial Discrimination Act. They could have brought a defamation act and they would most likely have gotten a damages award, which means they would have been personally enriched by that. Now that raises a whole interesting set of other questions about why people would want to police speech. I mean, we know that politicians in particular, of both varieties, of all varieties, use defamation laws to police speech through the civil courts, as it were. And there's a whole bunch of other interesting issues about the personal enrichment that comes from defamation payouts that is absolutely alien in Section 18C cases.
I think we have a question just over here.
Thanks. I'm Hannah Robert. I work at the law school with Patrick High. My question was sort of working from the last question a little bit about, okay, how do you go about not offending Section 18C? And I quite liked Shen's kind of view, and I just wondered whether the panel agreed. Michael Mark Cohen, who is a US academic who writes on whiteness, has suggested that the shorthand for not offending Section 18C or not being racist is don't be a douchebag. It's a great article, I recommend people read it, but I guess it's kind of picking up on this idea of it's someone who has privilege being incredibly entitled and not caring about harm to other people. And I mean, I think John Stuart Mill would be with us on harm being the line where our freedom ends if we're causing harm to others. And I just wondered whether you guys think the douchebag definition is a useful one.
Start over here.
Yeah. Hi, Hannah. I agree with you with John Stuart Mill as well around the harm principle, and yeah, that's a great idea. I'll have to read. I haven't read the article. I'll have to give it a read.
So John Stuart Mill specifically addresses the issue of offensive speech. And he doesn't address it in the area that he talks about the harm principle, because the harm principle, in his view, or my reading of it, it refers specifically to action and physical action. He does address the question of offensive speech, and he says that the offensiveness of the speech should not be seen as a reason for censoring the speech, because the underlying idea needs to be aired, or should be allowed to be aired, not needs to be aired, but should be allowed to be aired in order to get the intellectual growth benefits that he hypothesizes come from freedom of speech. So he does specifically address that. To the being the douchebag, don't be a douchebag issue. I think that's a really good idea, and I just want to raise one conceptual point. About the idea of self-censorship that gentleman raised. So I do think that legal restrictions on speech encourage self-censorship. But self-censorship itself is not necessarily bad. We're always self-censoring. I mean, I'm self-censoring now. I'm not standing up and swearing. I'm not.
Please feel free.
Yeah. we all self-censor. That's society. You know what I mean? That's just the nature of it. We talk about this a lot in the privacy space as well. You're always presenting a face to the world of some description. You're always in different contexts saying things or doing things differently depending on those contexts. Well, I am deeply concerned if that self-censorship comes from not a sense of society the social consequences, but the legal consequences. Well, this might end me in a conciliation process, or this might end me in court. But self-censorship, I don't think is a fundamentally bad thing. It's not the first case against this. The "don't be a douchebag" rule is it's perfectly libertarian. We'll put it that way.
Some more questions.
Just a question about the idea of speech that could be harmful to certain people. And a lot of people mentioned like the idea of whether it's true or false as like a determining factor. But are there ideas that can be factually true and still be harmful? Like, for example, a lot of academics might do study in ideas of racial genetics, for example. So if you have a view that different races are different based on genetic factors, can that be something that is going to be susceptible to those kind of laws?
Because it has been problematic in the past, because that it's been politicised and discredited in some ways.
I'm going to give you a slightly theoretical answer to that, which hopefully will be meaningful in the end. There are two theories of freedom of speech. The first one is the John Stuart Mill one, which is commonly called the marketplace of ideas. That's the idea that the truth emerges out of this debate and out of the airing of all views. Now, the problem with that idea, in my view, is what if society decides it's not interested in the truth for whatever reason? No, what if it decides that it doesn't want to know a piece of information now? I very much doubt that research is correct, but imagine that was correct. What if society decided, well, we don't actually want to know? That, to my mind, doesn't seem a very safe basis in which to defend the principle of freedom of speech, in which to defend democratic discussion. What I do think is a much more fundamental base is a more recently developed one in the last couple of decades is basically it's the liberty principle. It's the idea that there is a fundamental right that you as a person have to speak your mind while not causing physical harms or acting harms to others is the idea. And that's the one I'm sympathetic with. But it is a very live question. Now, in the US,
States at the moment, aren't we?
In the US, the Supreme Court has found that just because something is a lie doesn't mean a deliberate lie, doesn't mean it doesn't get protection of the First Amendment. So it is considered legitimate freedom of speech. Not desirable freedom of speech, but certainly can't be penalised.
Principle that's underpinning the entire Trump campaign, I think, at the moment. In this country, would an academic be allowed to have that discussion?
In private, you can have any discussion you like. Even under the Racial Discrimination Act, you can be as racist as you like, as long as it's in private. Once you put something in public, that's when the Racial Discrimination Act kicks in, and that's where it should kick in. There's a third theory around freedom of speech called, sometimes referred to as the democratic pluralist approach to freedom of expression, and that captures the notion that there's always going to be some sort of regulation of speech. I can't get up and yell fire in a crowded theatre like this one, and that's the classic example from the early Supreme Court decisions in the United States in the early 20th century. So there's lots of regulation of free speech, and even Chris and libertarian folk in Australia aren't advocating necessarily to abolish Section 18C. They're just talking about carving out a couple of words in Section 18C. So there's a distinction drawn between humiliation on the one hand and offending or insulting on the other. And so that's tacit recognition of the fact that we should have some regulation of speech. The question then becomes, who regulates it? And the answer has got to be the Parliament. I mean, that's our democratic institution. We may not like it, but it is democratic. And we have a House, we have a Senate, that's their job. They can do it. If we don't like what they do, we can kick them out in an election and have something different.
And at the moment, it seems at least we still have some sense of trust that the compact between the people and the political process remains somewhat intact. Whereas in the United States at the moment, that power that you talk about is severely under strain from a whole section of the community that doesn't trust its government to act in the best interests of the wider community in relation to these matters.
Yeah, well, I guess, I hope I don't sound elitist when I say that there's a need for very significant civics education in that country and in this country. And perhaps digital ethics, which my colleague Nicola spoke about earlier, is going to be part of that civic education that we need to have people involved in. I mean, it's great to have a marketplace of ideas, but there are no unregulated markets. We have a
Going to
market.
make Chris cry, mate.
We have a market. Economy in Australia,
And I'm working on it.
I think it's great that we have a market economy in Australia, but I'm really glad that we have an Australian Consumer Law and a Trade Practices Act. So the marketplace of ideas analogy is one thing, but the reality of it is, it's not a level playing field for everyone. So thank goodness for regulation.
Sorry, I've got my first caveat is I'm fairly naive and shocking with names. But the four people, the three gentlemen and the lady to my right, seem to be arguing over the beige, the off-white and the grey. The lady to the right who's talking about imagery, which I think you're on the left from your perspective.
On the right.
Sorry, as I said, I'm ignorant. You make a very valid point about imagery in as much as it's revocable and takes 1,000 words to basically describe an image. The other guys appear to be talking about nuances that, in regards to freedom of speech, appear to have a caveat that freedom of speech is controlled. Now, freedom of speech, especially in the social media, has the opportunity to have oppositional points of view, which is the balancing act. So I guess my questions are, is offence given or taken? And the other question is, who is your target market for this audience? Is it this group or is it the Australian population? The reason being because, if you look at a broader community sense of point of view, freedom of speech is widely taken by many Australians, and they have the right to agree or disagree, and they can also...
I'll stop you there because we've got to move on, but I'll take the first part of your question. This conversation is the start of a wider conversation and is available, will be available via the Trobe website. So it's not just about what happens in this room, but I'll also say to what you just said there, people might be free to express themselves, but they are still subject to the laws of defamation and the laws of the Racial Discrimination Act. I mean, people are aware that there are consequences for what they say, and that's in our current context, even in a robust democracy like Australia. There's no sense that I think anyone in this room or anyone watching beyond thinks they can say whatever they like without consequence, whether it's legal or personal. And the things that you say come with consequence. And I think that's part of the key component of what we're talking about.
Yeah, it's a really interesting point. I think that there are a lot of people, particularly in the online space, that think that they can say what they like. And there was a recent case in this year, actually, a Sydney man got drunk and went on to Facebook and wrote about comments on another woman's photograph and kind of abused her, but also wrote comments about raping feminists and all sorts of things. And he actually did go to court under the telecommunications legislation for using a carriage service to menace, offend or harass. And some of the comments from him was that I wasn't breaking the law, and this is also the case in relation to this intimate imagery stuff. And there was a guy in the US who ran a revenge pornography site, and likewise, his defence was he wasn't breaking any law, and actually he wasn't prosecuted under legislation in California for hosting that site, but he was prosecuted for computer hacking and identity theft. So I think that there is this problem that people think that, and I think this hopefully relates to your question or your comment, that people do think they can do whatever they like online. And, I think this is why these conversations are important, because there are laws in place to prevent people from causing harm, making threats online, distributing images without consent and so on.
The law isn't static either in this case, and there are two parts of the conversation. So Section 18C itself is evolving and changing, and it's particularly evolving and changing in relation to social media and exactly how that plays out. The next judgment under 18C will make Section 18C in practice operate a slightly different way. One of the reasons that the QUT case has dragged on so long is because for both sides of the argument, it's not totally clear where the lines are drawn, where a future judge will draw them. And certainly we're going to see a lot of really rapid change. We're already seeing it, but we're going to see a lot of really rapid change in the way the laws on the books be applied. Now, my preference would be to see how that evolution goes as we go through this unlearning experience as a society, rather than jump on and say, well, yeah, there's obviously a case for more law. I think we've got some very robust laws, and we need to test them and find them and discover whether we have problems or not.
I think we have a question down the front here.
Thanks. I think the majority of the people wouldn't know anything about Section 18C. What I feel is that the media typically frames a world that's very violent and aggressive and fearful, as distinct from portraying a view of a world that's very kind and compassionate. And anyone who's been on Facebook, any form of social media, will see that both sides are reflected in this world. I don't believe you can legislate freedom of speech, but I do believe that you can educate people to learn respect. I totally agree with you, Nicola, on values-based education or ethics. I think most of us are not speaking face-to-face, and we're not knowing how to speak with respect. And that really means sitting down and deeply listening. And of course, that's what the Indigenous people taught us, was to actually sit and listen. Much of the problem, I feel, is that community is broken down, and we have an imagined community from which we see, and that community is very much shaped by various commentators in the media who have stronger influence than, say, your average person. I think we have to face life in all.
Yeah, I was going to say, do you have a question for us?
Yeah, I'm coming to it. I believe we have to face life in all its colours. So what I wanted to ask was, what do you think of more community development where we actually develop forums, where we build community and we get to know one another?
Well, if it's come to the point now where we have to actually consciously build communities rather than live in them, we're already in a bit of trouble, aren't we? Well, I think that's part of it, though, isn't it? That part of living in a community is living, talking, experiencing each other.
I mean, I think that sounds like a wonderful idea. I think it sounds like a wonderful idea, and I think changing Section 18C to allow people to offend or insult people on the grounds of their race is not a way to meet your objective of getting people to talk together as communities and to develop the civil society that I think you're seeking. And so, in one very small respect, I'd disagree with what you said, or maybe just qualify a comment that you made. We may not be in disagreement, and that is, I think you can legislate free speech. I think we already have legislation for free speech. In fact, the distinction between Chris's libertarian position and my position, and perhaps Shen's position as well, is that we don't think that we should change Section 18C to allow people to offend or insult people on the grounds of their race. And isn't it wonderful that we're in a society where we can have these discussions peaceably? And a large significant factor there is the rule of law and the rule of courts. So let's not forget the courts do have an important function to play. They're actually involved in very, very few legal disputes in the country, but thank goodness for our courts. Thank goodness for our independent courts, which apply our legislation and allow us to resolve these sorts of disputes peaceably.
Shen, can I move it on just to the discussion about the lack or loss of community? And you work in the online and digital space. You do a lot of work in there. Has the access to that digital space has been a boon for a lot of people because they get to join the conversation, but the siloing of conversations, people decamping into like-minded communities where they speak in closed talking loops and not with each other and opposing points of view, how much damage has that done to our civic discourse? And is that part of the problem why the issues around 18C and freedom of speech have been in some sense accelerated, because we no longer have a way of having a civil discourse?
I mean, I suppose the way I can respond to that is with an example. So we, as you said, operate a lot in a digital space. My team is a human rights team, so we cover, race, refugees, LGBTQI community. And on any posts that we do on the internet, we have a Facebook page and we put up about 5 or 6 posts a day. My staff have to spend more than double, so at least an hour to 2 hours moderating any post on our topic areas because of the level of abuse and hate spewed forth. And we just pretty much, quite often, people have to spend hours just deleting posts and things like that. So I think the question, and we struggle with this, like, why is that? And I'm not 100% sure. I think there's 3 main areas that we can think of. First of all, it's that people say things online that they wouldn't say at home. Doesn't necessarily explain why there's that much hate about this subject area and not others. Secondly, maybe, and the hate is worse if it's a person's face, right? So if it's particularly personal, if there's a personal subject for that hate, the amount of time that we have to spend on the internet is far more. So then the question is, maybe that's what they were always saying at home, but their home never came, for instance, in touch with mine, so I just never had to hear it. Yeah. So maybe it's not that they are saying more stuff on the internet that they are not in person, it's just that I rarely have to come across people like that, and they rarely have to come across people like me. So there's that. And then the other thing is that there's organised groups of hate, which is also a part of it, because following the election of Pauline Hanson, it was really clear that there were specific trolls that were spending a lot of their time on the internet, and that rise has also tracked the rise of kind of right-wing fascist groups on the issues of race. So I'm not really sure, to be honest, and I think we need to do a range of things, but I think the second issue is, are people just being able to say to people like me or in public what they have always said at home? That tracks according to the rest of the polling that we've got out there that tells us that Australia has a deep problem with racism and with, LGBTQI community and a host of other issues that sit under the human rights banner. So I feel like there's something to be said about dealing with that in order to be able to have a civilised debate, because I don't know how you can have a civilised debate when that hate spews forth, and then when that hate just circles around a tiny online community. It's kind of horrifying.
Well, I think we've had a civilised debate here tonight.
We have.
It's been great to have you all involved. And thank you for coming along as well, and everyone watching also online. Can you please thank our panellists, Nicola, Chris, Patrick and Shen. And we do have one more Bold Thinking Series event that's coming up, and I've got it in my little phone here. The Education Revolution, Whatever Happened to the Clever Country, that will be happening here on Wednesday the 23rd of November. Wednesday the 23rd of November, it's our final event for the year, and it does talk about the future direction of education policy in Australia and the so-called Promise to Education Revolution, what became of it. So, hey, come back for that one. We'll be here. Thanks for coming along.